All right, welcome everybody to the Richmond Legal Business Design Hub. We've got a great program here for you looking at court forms and how lawyers may or may not be getting in the way of helping self-represented litigants navigate the court system. Before I introduce our guest, I just want to sort of set the stage a little bit with the current state of our court system. Before I do that, let me just give you a little background about what we're doing here at the Richmond Legal Business Design Hub. We're all about building and helping our law students become the modern lawyer. And we know in traditional legal education, equity, the rule of law, rights, and justice, these are sort of the bedrock foundation of the doctrinal classes and the foundation of building that lawyer brain. But we also know that in 2023 and beyond, there's new skills and new capabilities that are available to lawyers that if they get them, they'll better address the needs of society, of the client base, and of themselves. And so what are those? Those are really understanding the business of law, how legal services are delivered, not just for profit, but in legal aid too. And we're going to dig into a little bit of the business side and operations side in our case study today. Obviously, the use of technology, it's everywhere. We don't have to become coders or data scientists or software engineers, but we have to understand how we can use technology to better serve our clients and not let it get in the way of us being lawyers, but actually use it to leverage our legal services. Design, as things continue to grow in complexity, we have technology, we have process, we have systems, we have very, very busy lives. We have a justice system that may or may not be, helping us. We've got to be thoughtful and intentional about how we create the interactions for ourselves and our clients and the general public with the legal system. And that comes out of the discipline of design. And then finally, probably my favorite, although I guess they're all my favorite, but entrepreneurship. And that is seeing the opportunities available. Yes, status quo serves a lot of needs. And I am not here to say that anything is wrong necessarily with the legal profession. And that's not our stance. Our stance is we could be doing so much more. There's more opportunity that we're not seeing as a profession for ourselves, for our clients and society, and tapping into that entrepreneurship brain. That's what it's all about. So our guest today is Kim Craig. Kim comes from a very, very long and experienced history of doing process engineering and introducing a process mindset, not just to become more efficient, not just to, work smarter. Yes, that's great. But it's to serve more people. It's to look at what a lawyer does and ask, how can the lawyer not just serve one person by behaving and acting a certain way, but how might we help one lawyer serve 10 people, 20 people, 100 people? And she's a Lean Six Sigma black belt. She's trained thousands of legal and business professionals in this. And to list where she's been a guest expert lecturer or adjunct in law schools across the country would just bore you to tears. Needless to say, many of them, including right here at Richmond. Okay, so this is the Court Forms and Access to Justice case study. And let me set the table with what's currently going on in our justice system. So generally speaking, this is how we size the overall market. And really the takeaway from here is just look at the people side and the business side. And I'm going to keep on breaking this down. This might be a shock to you that the overall industry is $320 billion. This is in the US and $84 billion is people, but that's kind of meaningless. These are big numbers. So what does that really mean? Well, let's look at the trends. On the left-hand side, 2007, you can see the people and business distribution, and look at what happened 10 years later. In 2017, the number of people being represented by legal services compared to business is dropping. And by the way, that trend continues. We only get this data once every 10 years. So we won't get more of this until 2027. But we know anecdotally and through other various studies I'm about to show you that people are becoming less and less a client base for lawyers. That's a problem. Let's look at some of these statistics. 86% of low-income Americans with a civil legal problem receive inadequate or no help. 76% of all civil cases in state courts have at least one self-represented litigant. They don't have a lawyer. And There's some other things here. I'm going to move on to get to some really scary facts here. Let's just break this down. In some states, as many as 80 to 90% of litigants are unrepresented. That might be shocking, even though their opponent or the other party is represented by a lawyer. In some counties, think about this, in landlord and tenant court, 90% of the landlords are represented, while 90% of the tenants are not. And look at the win and loss ratio. When a tenant represents themselves in New York City, they're evicted nearly 50% of the time. If they just had a lawyer, they win 90% of the time. So having a lawyer matters, being self-represented matters. It has direct outcomes. And if you look at this next one, researchers in various states have identified almost 200 discrete tasks that self-represented litigants must perform in civil cases by themselves. 200. It's intimidating enough for a member of the general public to walk into a courthouse, to know where to go, to understand the forms, to understand the process. It's a very foreign territory and can be very intimidating. And here we have roughly 200 discrete tasks that a self-represented litigant has to do just to advance their civil case. And then, so fine, we have forms, we have court forms, and we're going to be digging into that momentarily. But look how long it takes basically to generate a form and publish it for the public for a self-represented litigant. There's committees and there's judges and there's lawyers that are all working to create these forms that are supposed to be helping these self-represented litigant. And they are, okay? They are helping. No one's saying they're not, but this is taking on average 2 to 5 years just to get a form published and even updated when they have to update the forms. So let's look at the impact. Some quick stats here. I'm going to move through these relatively quickly. Look at the median judgment in state courts. It's about $2,000 to $3,000, right? The average is just under $5,000. That means how much is at stake? How much the self-represented litigant is gaining if they win, right? So think about that in terms of attorney's fees and lawyers' fees. It's not even affordable. They'll probably lose money hiring a lawyer to get their average judgment of $5,000 or $2,000. It just doesn't make any sense. That's why they're representing themselves. And because it's so intimidating, we're finding around the country that there are fewer and fewer civil case filings being filed. So this is just a snapshot of Illinois circuit courts. Just look at the trend line, right? This goes up to 2016. It continues. This is some more recent data from 2016 to 2020. On the top, you have law cases of $50,000 or less. On the bottom, over $50,000. You don't have to look at the numbers. Just look at the trend lines. Fewer and fewer people are filing fewer and fewer complaints. They're literally trying to avoid the legal system, a legal system that was designed to help people. And now we have the vast majority of the public trying to avoid it. Again, not a good look for the profession. Just to contrast this a bit with another state of Ohio, again, a lot of numbers. Just look at the first column, 2011, look at the last column, 2020, and you'll notice that every number in the 2020 column is smaller than the 2011. Case filings continue to go down. So basically, our industry is evolving. This graph and this concept that I'm showing you here, this one-to-one and one-to-many, has been popularized by Professor Bill Henderson out of Indiana University, Maurer School of Law, basically showing the problem. We can't survive, we can't address the access to justice gap based on a lawyer to one client, one-to-one. We've got to figure out ways to address client needs in a one-to-many product and service. And that sort of tees up this whole challenge of how do we do that? Lots of people will say, pro bono, that's great. Well, here's Justice Dino Himonis. We cannot volunteer ourselves across the access to justice gap. The demand is too high. The amount of available lawyers and the time that we have just isn't there. Here's another one from Honorable Catherine Schneider, Cook County, Illinois Circuit Court. Our court system was created by lawyers for lawyers. Standardized court forms are key to advancing access to justice. So this doesn't mean we have to create more lawyers. We have to just create more tools that the public can use to advance their cause. This is a great quote from Judge Scott Schlegel out of Louisiana. Basically, I asked him, can you give me a quote to help my students understand what it's like to be a non-legal person? And he said, yeah, just tell your students to pretend they're getting married and take public transportation to the court and try to change their names. They will immediately realize the need. the point of this is it's stacked against the general public. It's not easy just getting to the courthouse. Once you're in the courthouse, finding where to go, understanding the court forms. Nothing here is designed well for the general public. It's designed for lawyers. So with that, I'm going to stop sharing my screen and introduce you to our lovely guest, Miss Kim Craig, and we will take it from there. Hi, Kim.
Hey, Josh.
So what stood out? You've never seen me do that preamble there, and I apologize if it was a little long. But what resonated with you with some of those facts and figures that I just shared? Like what pops out or what's your reaction?
Well, I think you hit on, it's a core thing is there's underserved and it's not just about more lawyers and throwing more legalese at them. It's like, how do we help that? And it's intimidating. It's so intimidating that, as you showed, not only are they not using lawyers, but when they do, they want hand-holding through the process. They're so afraid that answering one question wrong, it's a matter of sometimes life and death for them. I mean, are they going to have a home to live in that night? Are they going to have custody of their children? Like these are life-changing decisions. And so you're sitting there staring at a form that you don't understand and really not sure what the right answer is. So how do we make it easy for them? And that's what really stuck out to me and resonated as I think about the project that I just worked on.
I think you bring up a really good point. Like we take it for granted. We think of a form as like, just check the box literally and figuratively. But the thing that you just pointed out is to many people, the fear, the absolute paralysis of checking the wrong box on an official court form and the implications of that. And I think we could all probably agree who's watching this, like undoing bureaucracy that's set in motion by once we file the form, like if anyone's like accidentally screwed up their birth date, right, in a state system of and then like changing that, it's like 10x the work. So there's just the work, but as you pointed out, there's real human consequences for it. All right, so I think we've set the table that we've got a problem. We've got several problems. It's not a very user-friendly system. It's designed for lawyers. We have immense need. People are literally doing anything they can to avoid us, which means probably getting taken advantage, probably being unable to press their rights, not even knowing what their rights are. All right, so just some pretty horrible situations. So, introduce the project and the organization you worked with and what really was the challenge that was set out before you.
Sure. So I had the privilege of working with the Administrative Office of the Illinois Courts. Part of the access to justice from the Illinois Supreme Court, one of their primary missions is to create standardized forms for SRLs, for self-represented litigants. And they do see it as that is the way that they improve the access to justice is through these forms, through this vehicle of communicating with the SRLs. They were already in process of how do we redesign the form? So that was kind of a project they had going on. How do we make it a bit user-friendly? Some of the things we've just hit on, but also realizing just like most of the state agencies out there, and many across the country have been mandated with, creating these standardized forms, but they're resource constrained. They rely heavily on volunteers across the legal system. It could be lawyers from big law, it can be legal aid organizations, clerks, judges that are all volunteering their time to try to create these standardized forms. And then you have a staff like the AOIC, the Administrative Office of Illinois Courts, trying to shepherd this whole process. And in the 10 years or so since they'd been charged with kind of this mandate, they've done a tremendous job getting those forms out there to the public. And Illinois has a challenge of standardizing across all of these different counties. And so getting alignment and agreement, a form that will be accepted by all.
Right. So it's like Right, just getting the people in one county to agree, but they have to actually, they're mandated to have all counties use the same exact form,
Yeah, that's
which makes
what,
sense, but I can't even imagine what that's like.
and so they have that somewhat sense of urgency, like we need to get these forms out there, especially once a form has been identified as a need. And that usually is coming in from the public or a judge or a clerk or just the legal aid organizations themselves. Okay, we need to get this form out there. At the same time, there's all these competing demands on their time and process that they go through to create these forms, manage the volunteers, and let's face it, having a volunteer set of members in these committees is wonderful, but it's very hard to set deadlines, to, set expectations and kind of dictate to them. They are one of the things we discovered in the project is we thought of all these different stakeholders involved in how do we improve the process. So AOIC, similar what we found to many agencies across the country, 2 years or so average to get a form from inception to public.
So let me just stop you there. So like when you say inception, like so somewhere along the lines, and you may or may not know this, like there's a need for a new type of form, and that might be coming through the clerk's office or a judge or practitioners, right? And so the AOIC is like they're the conduit to like take that and then say, okay, do we need a form? Yes or no?
Right.
And if so, what should that form be? Is that an accurate portrayal of? Okay.
Yes, and some of it could be instigated by new laws, regulations that have made something
Right.
more critical at the time. If you think about COVID and all the fallout from that and housing and how it impacted, tenants and landlords and stuff, like those would maybe force those types of forms to be created or prioritized or updated and changed. So
sorry, just to kind of compound the problem. So every time there's a regulation or law change, the forms that may be impacted by that have to be identified, and then they have to be reviewed to make sure that they're still, doing the job of the new regulation and changed.
So you're hitting on the tension. You're hitting on the tension right away. Is the committees, the volunteers, are charged with creating a form that meets legal sufficiency, right? So if lawyers.
Wait. Okay, sorry. So legal sufficiency, is that a term of art? Is that the actual language in their mandate? Like it has to be legally sufficient?
Pretty much, yeah. I mean, I've seen that term.
Sounds very squishy.
So,
yeah,
defensible, that it's abiding by the laws. Like it's a good form. It can stand pressure from others that don't think it's the right thing. So it has to be legally sufficient. At the same time, so think about all it takes maybe to create that form across all the counties and jurisdictions, like standardized for that. At the same time, there's like, oh, but we need it. Like there's an urgent need or there's a law just changed. So we need to do that. Like, so you have a sense of urgency, but also balanced with, but it's got to be right. It's got to be.
Yeah, so going back to your example, COVID's a great one. So especially in landlord tenants. So as COVID hits and people's lives are thrown upside down and landlords and tenants are becoming at odds in new types of ways. Some laws change, some regulations change. And if it takes 2 years, I mean, we're just beyond 2 years of that happening, right? At the beginning of COVID. So those forms are just now the ones that are more COVID relevant, might be just coming through the cycle, which kind of, I guess, still useful, but they weren't available at that time.
And part of what happens when the form isn't available, either the person, doesn't have a mechanism which they understand and can use, so they have to rely on clerks, or they have to find a lawyer, or they can go to, like in Illinois, there's a Illinois Help Center. Like there's some different ways, but if that form isn't there, the other thing that sometimes happens is those other jurisdictions, those other courts, they'll just create a form. And so then you start having that form in all these different variations, and maybe hasn't gone through the rigor and test of the meeting legal sufficiency and such. And so then people are using different forms, and it gets a little chaotic.
Yeah, I can only imagine. I mean, kudos to the jurisdictions that said, listen, the urgency is so big, we can't wait to go through the process. So good intentions,
Right.
fixes or addresses the short-term problem. But the
Right.
long problem is actually compounded because now you got various forms and various jurisdictions. And okay. So we've talked a lot about the problem, right? And I think there's so much we could go into here. You know, we've got a need, we've got a user in the self-represented litigant who is confused, possibly intimidated, concerned that representing themselves and using a form is going to put them in the best position possible. And we've got a backlog of forms. We've got a mandate to make them uniform. Okay, so AOIC, which is the acronym for the organization that you worked with, what was their goal? What was your goal? Like, what was the milestone you were driving forward with them? You had to succeed, and what did success look like?
Initially, everything was around, it takes too long. All right, so that's a bit ambiguous, like takes too long compared to what? Like how do we trim that down? And ultimately it was like, how do we increase the volume, the throughput of forms that we're releasing to the public to meet those needs? And so it was like, can we get that cycle time down from the average of 2 years, which again, across the country, it's pretty standard. We actually talked to somewhere, sometimes it's 10 years. Imagine that. And as you go through that 2 year, is it still timely? Is it still current, or is it actually ready for review? So it was, can we get that cycle time shortened so that the effort and work in creating that form, we know it's current, we know it's up to date, we know it's legally sufficient, and get it released out there. And so their focus, I mean, kudos to this team, because a lot of organizations would take this into their back office and figure out, how do we do this? How do we use tech? Maybe we can just use tech to solve this. The process had been in place for quite a long time, and they were trying to be deferential to those volunteers. So one of the things that was great in having all of these key stakeholders involved in the project, as we took them on the journey of understanding current state, what's happening today, how's it work? Josh, there were so many aha moments that they hadn't realized. And, just the drafting of the form, and it goes before the subcommittee, and there's 13 subcommittees and different practice for each.
Of course there is.
Right?
Of course there's.
It could have been 6 to 13 members on each subcommittee. So they're working through drafting that form. And then when they think it's pretty good, it was going to the forms committee. One of the other challenges with the forms is that they need to be plain language. So that's typically like a fifth grade reading level. So imagine you start lawyers drafting these forms, and then one step is, okay, now we need to make sure it's plain language. And another part was, and we also have Vallejo, who will also put document automation around it as an option. So
what's a layout? Just
Illinois Legal Aid Organization. So they do document automation and other things. So they have the technology that once the form was good enough, would hand it over, and they would put the interview guide on there. So to help people complete those forms.
Okay, so I'm lost and confused in the number of things and plates spinning and people and all that. So, like, how do you get your arms around something like that? Like, what is the work that you did to like orient yourself, orient the team? Like, how did you manage this? Like, what did you have to produce to like get orientated and organized to figure out what's going on and where to focus?
one of the main things we did was to visualize it, make it visual for everybody to see. So we had the whole team together, and we had each person talk through like what they did when, you know, the form was handed off to them. What were those activities? And so we created a process map that represented each of the roles in these handoffs. And what was great about it, there was this transparency all of a sudden in the process where people hadn't realized all that it was taking to get a form to this point. And like, this is one page of the form.
Right. I
And
pulled this up so people could kind of see, and I know the writing's kind of small, but like, yeah, what are we looking at here? Like, help us
so
understand.
step by step of how the form comes in as a request and then how it gets prioritized is, you'll see black dots on here. So the black
Right.
dots represent the team saying these are huge pain points, friction, waste in the process. And you can see for some of that, if it was bigger, like that first one with a lot of black dots, the several
Yeah.
black, it was because they were waiting for resources, waiting for people to be available, right?
Got it.
And then
Okay.
upper right-hand corner was the subcommittee, and they began calling this was the turns on the document: revise, edit, review, revise, review. And so it
Right.
became
There's
like
no done. That just keeps on going around and around
right,
in this committee, right?
the circle of death. It was they started calling it the circle of death. And it's because the subcommittee and then the forms committee, who had the same thing, once it was good in the subcommittee, it would go to the forms committee and they'd go back through the whole thing. Well, here's our suggestions: review, revise, review, revise. So they had their own circle of death. The best moment was when one of the key stakeholders said, "Oh my gosh, we're part of the problem." We're part of the problem because we're seeking perfection. You know, they're
The lawyers were, the
lawyers,
committee was seeking perfection. Right.
right? And it was causing delays, and also because of the cadence of the committee meetings and such, it just drew everything so far out.
So going back to the quote, then I think it was the judge you were working with, and the quote that we used in the beginning.
Yeah,
So the committees were reverting back to designing the forms for lawyers, not the user. When you say perfect, they
yes,
wanted it bulletproof from a lawyer perspective, and they sort of lost sight of the fact, no, we're designing this for someone that is not a lawyer and doesn't care about perfection. They care about fixing their life in some
right.
way.
I think
Okay.
one of
No,
the
go.
best things we did was also talk to other agencies across the country to find out, did they have some magic that they had figured this out? And here's the good and bad news: no, they haven't. But they were looking to AOIC, like, if you figure this out, like, we're looking for a model. But what was interesting, one of the agencies said they had started looking at the forms, not so much just, is it understandable, is it usable by the SRL, but can it solve the problem? So the example was not paying rent, you know, and so trying to file judgment against the tenant for not paying rent. And ultimately what the landlord wanted was to get paid. So they had started converting their form to a payment. Like, it had checkboxes: I can make this payment plan, I can do this. And it was like really just moving from that form to solving the problem.
Right. Not creating the legal case, but just solving the actual real problem.
Right.
Um, so let's spend a couple minutes just like talking about your discipline, right? So and why law students listening to this should care, right? Let's just delve into that, because this could probably come across as extremely boring work. It's not the sexy cool stuff. It's like, oh my gosh, are you literally trying to get us amped up about creating form creation process? Yes, yes, we are, right? Because this goes back to the problem, right? If we can't, as a profession, don't we have an obligation to create interfaces, forms, that the general public can use? So why you? Why were you the right one to work with AOIC? What do you bring that's unique that they were missing? Like, what's your secret sauce?
Well, I think part of it from doing process engineering for so long in legal and having the opportunity of working in legal aid and nonprofit centers doing that, I realize so much that it's the change experience, the change management piece of it that was just as critical as anything else. Because what we ended up with, the future state prototype that we created, I probably could have done that the first day or two, but they needed to go on that journey so that they were
Right.
craving the change and they owned it. They owned their own behaviors and they owned they were going to have to convince others who weren't in that room, who weren't going on that journey, like why this was going to be important to change their approaches, why they were going to shift responsibilities, why they change the structure of the volunteers, put term limits and things like that. So it was that change experience that they went through. That's my secret sauce, that they craved the change, not me pushing change.
Well, I think you just hit on something fundamental there. It's like you said, you could have probably come in and told them a better way almost immediately, right? And my guess is they probably could have told themselves a better way, right? But it's like you got two dilemmas. You go, okay, well, which better way are you going to do? Because there's going to be a difference of opinions. And then how do you make sure it sticks? Because to your point, you can build future state on a piece of paper, but humans being humans are going to revert to what they want to do, what status quo is. So you're saying that through, yes, Lean Six Sigma and being able to break down a ambiguous and multifaceted process and problem like we've described here. Yes, you need to have the tools and the mindset that Lean Six Sigma and process engineering give you. Like that process map looks very clean, but being a green belt myself and working on some of the stuff with you, it's insanely messy, right?
Yes.
At first. And you've got everyone trying to plot everything. So there is a discipline, but it'd be a mistake to just focus on that, because what you're saying, I think, is key for everyone to understand that you can't do that in a vacuum.
Right.
You've got to get as many stakeholders in the room. They've got to feel the pain and they've got to arrive at their ahas together, because otherwise they don't own it.
Like most teams, they'll come in, we just need more resources. We just need technology. Like they're jumping to solutions. And the Lean Six Sigma discipline, it really, if you follow the methodology, it forces you, it prevents you from solution jumping. It makes you do that work so that when you are ready to put a solution in place, one, you are craving it, you're ready for it. And two, you've identified where the berries are going to be. Not everybody's going to be a champion, but you've built the business case, you have evidence, you have data to support like why we should do this. So I think those are key as well.
All right, let's sort of switch gears and look to wrap this up. Like, why, in your expert opinion, I mean, you've worked with many law students, you've taught many law students, you've taught many lawyers this, like, why should a law student care about this topic? Like, what's the key learning takeaway that you want to make sure that we hit on here for a law student?
Take a step back and really think about, what is the problem that we're trying to solve for? What's the job I'm trying to do here? Is it just to, get those court filings on time and, check those boxes? Or is it to how you're communicating, sharing with the client, the transparency, how you communicate with your team and share with them, like, what are we really trying to do here? What's the strategy? What's the end goal of it? I think if you can keep that in mind, like what problem you're trying to solve, just like you said, the form, like how could we reuse a form to solve the problem? Thinking in those terms will lead to a different type of relationship with your peers and your clients.
Yeah, it goes back to your example, right? It's like just help the landlord and tenant get paid. Like help the don't get so concerned about creating a Supreme Court worthy argument, right?
Yeah.
Don't. And I think that's the one thing I always try to express to students. Listen, they pay a lot of money and spend 3 years of their life getting this education. So kudos to them for wanting to show off their knowledge when they become a lawyer and speak like a lawyer. They've earned it. They've earned the right to, and speaking amongst lawyers, we do use a different language. But you're not impressing most people, you're confusing most people, is what I say. So your, the law student's secret sauce is being able to convey complex legal ideas in a very easy to understand
Right.
language. I want to add mine, and if you got another comment, certainly jump in after this. I want to say the practice of law is not just thinking and acting like a lawyer. The practice of law is actually bringing the legal system to bear in the public domain, right? So we tend to forget that. So yes, this might be boring work, but think of the impact of designing a form, of being able to update a form. Like, yes, no one wants to take away representing a litigant. Like the lawyer-client relationship, it's a privilege, it's an obligation, it's a responsibility, absolutely. But not everyone can afford you, not everyone can find you. And sometimes a form can help serve hundreds, not just one. And so I always try to say that to law students, like, sometimes just doing this type of work, you're serving more people that you may never meet, but you're helping them advance. So that's sort of my takeaway. And you had another comment, please.
Just one last comment. One thing that was really interesting in this project was who actually became one of our focus as to who our customer was the court clerk. So think about that person, he or she is answering questions all day long, and they're trying to find the forms, and they don't know which form to use. And they don't know what's current. Like, they are actually the linchpin to that hand holding that I talked about, that like giving confidence to the SRL that, they're being taken care of. And so they were an extension of the AOIC and the forms committees. And they were actually the boots on the ground. And so if you think about and put yourself in their position, and I think that's going to be the same for your law students, sometimes your customer isn't the obvious, your client isn't the obvious one. It's that other person that's doing the interpretive dance for you.
That's a great idea, or a great thought. And we'll sort of end on this. I always ask, at some point in my classes, it comes up and I'll ask my students, so picture a courthouse, and you're not a lawyer. Who would you say is the most important person in the courthouse? And most people, and including most law students, say, it's got to be the judges, right?
Right.
That's the authority. And I'm like, no, it's not. It's the clerk of court, right? And now all judges I've ever talked to said, yes, that's absolutely correct, right? Because they're the interface. And then I asked the follow-up question. So fine, you're someone who's never been in a courthouse before. You may or may not be an English first speaker, and you see a sign that says clerk of court. What do most people think of when they hear the term or title clerk? They don't think this is an authority figure, right? They don't think that is a place to go. And just that alone can confuse people, right? It's like, well, to us, we know you go to the clerk of court, obviously, right? It's like, well, that's not intuitive to most people. So, all right. Well, listen, I appreciate it. Spending some time breaking this down. Where do you want people to reach out to you if they want to learn more about you? LinkedIn, Twitter, email, like what's the best way to get introduced or to continue a dialogue with you?
LinkedIn, or email me at my email address, kcraig@bulldogstudio.com.
Yeah, and I'll drop that in the notes as well. All right. Thank you so much, Kim.
You.
Really appreciate it. All right. Bye.
Bye.